Good afternoon or good morning, depending on where you're joining us from today. Welcome to the National Center for Truth and Reconciliation Week Lunch and Learn series. Today is day 4 of our programming, and we are going to be discussing the UN Declaration on the Rights of Indigenous Peoples. For those of you who are joining us for the first time, the National Center for Truth and Reconciliation is the body that continues the work that was begun by the Truth and Reconciliation Commission of Canada. We are so pleased to have the opportunity to engage in public education and support Canadians on the journey towards reconciliation in Canada. As I mentioned, our topic today is the UN Declaration on the Rights of Indigenous Peoples, and I'm delighted to be joined by a friend and a colleague, Karen Drake, and we'll have a conversation where we work to talk through how the UN Declaration and Indigenous peoples' own laws can really help us on this journey towards reconciliation. Before we start getting into the program, I do want to give Karen an opportunity to introduce ourselves.
Thank you so much. Ani bonjour, Karen Drake, Indigenous Cause, Wabagoni, Sagagan, Anishinaabe, and Donjaba, Toronto, Nangum, Inda. So hello, everyone. My name is Karen Drake. I'm a member of the Wabigoon Lake Ojibwe Nation. I'm also an associate professor at Osgoode Hall Law School, and I just recently joined a law firm called JFK Law on a part-time basis as counsel. And I'm absolutely delighted to be joining you and speaking with you today.
Thanks so much for joining us, Karen. And we had hoped Caleb Ben would be able to join us, but he has had something come up, and so he's not able to join us, but I think Karen and I can carry the day. So before we get into the conversation, I do want to set maybe a little bit of context for everyone on the journey of education that we've been going through this week. So on Monday, our Lunch and Learns focused on Indigenous peoples and residential school history, and we focused a lot on the North, just to provide some additional perspectives on residential school that doesn't often get explored. On Tuesday, we began exploring more about and Tuesday and Wednesday, we started exploring more about stereotypes and unconscious bias. So how colonialism in Canada has been built on certain myths, and the laws have sort of been created to support those myths and stereotypes, and the work we all need to do to start learning the truth and Indigenous people's perspective on the history. Wednesday, we started folding into the mix the ideas around intergenerational impacts of residential schools and how residential schools, even though that system's in the past, there are areas like the justice system, the healthcare system, the child welfare system that really continue to perpetuate discrimination against Indigenous peoples. And so that's where we end up now today, day 4, and we're going to talk about the UN Declaration on the Rights of Indigenous Peoples. So the UN Declaration, as it was spoken by the Truth and Reconciliation Commission of Canada, it really talked about the UN Declaration as a framework for reconciliation. And so, Karen, I want to start there with this idea of how does the UN Declaration provide a framework for reconciliation from your perspective, from your experiences?
Yeah, that's a great question, Brenda. So I think starting at the most foundational way in which it does this is that, number one, the UN Declaration rejects the Doctrine of Discovery. And then number 2, what it does is it provides that Indigenous peoples have a right of self-determination. And then the various articles in the declaration spell out what that means. And I just want to highlight that when I describe this, I want to, cite you, Brenda. I'm drawing on really your work when I explain this. So I think that those who are listening should know that Brenda is the leading expert on the UN Declaration in Canada, and I've been really grateful that she's been able to visit my classes that I teach as a guest speaker, and they've been able to learn from her publications. And so I just want to acknowledge that I'm really, saying what I've heard from Brenda when I describe this.
Well, thank you, Karen. And I should say you have done also amazing work, and I think have brought it into your own work. And I want to come back to this doctrine of discovery piece, because we do have a large audience from across Canada, from all sorts of different walks of life and experience. Can you explain a little bit about the doctrine of discovery for our very general audience today?
Yes, absolutely. So the fact that the Declaration rejects the doctrine of discovery is extremely significant, because the doctrine of discovery is still operative within Canadian law today, right now. So Canadian law, without the application of the UN Declaration on it, still enshrines the doctrine of discovery. And I emphasize that because, and I'm going to explain what the doctrine of discovery is in just a second, but I emphasize that because people will often say when I talk about it, oh, well, the doctrine of discovery is from history, right? That's from 100, 200 years ago or more. Get over it. That's from a long time ago. However, it's still operative right now at this very moment. Okay, so what do I mean by that? So what the Doctrine of Discovery says is that when one nation discovers foreign territory and claims it for itself, then that territory belongs to that nation. However, the original principle says that that territory must be empty, right? It can't actually be someone else's territory. So for instance, we can't go over to Britain right now and show up at Buckingham Palace. And for instance, if we're Indigenous people, we can't put down our tobacco on the land and say, oh, we now claim Britain for ourselves. We're now sovereign over Britain, right? That's not going to work because British people are already there. So originally, the principle says this works when territory is empty. However, the Doctrine of Discovery twists that principle and says that European nations can claim sovereignty over territory even if it is already occupied, and even if there are already people who are sovereign over it, if those people are Indigenous people. In other words, the Doctrine of Discovery is based on the premise of the superiority of Europeans over Indigenous people. It's based on the assumption that Indigenous people are inferior to European people, that Indigenous people don't really count when it comes to exercising sovereignty over their own territory. So the Doctrine of Discovery says that when Europeans came to what's now North America, they could assert and claim sovereignty over this territory just by showing up and planting a flag or planting a cross or making a declaration. On some versions of the doctrine, Europeans also had to eventually fill the territory with their settlers, or in other words, occupy it. There are many different variations, but even on that version, it still is based on the assumption that Indigenous peoples are inferior, right? That you can simply claim the territory and occupy it and then somehow get sovereignty, whereas it doesn't work the other way. So that's the explanation of the Doctrine of Discovery.
Thanks. That was awesome. And I think now, like, connecting us to our learning journey this week, we know through our learning this week and that residential school system was based on that same idea of supremacy of European ways, right? So on Monday, our guests talked about residential schools as institutions and not schools, right? So they weren't places where you sent children to go learn reading and writing, but rather they were institutions to, European, to introduce European ways and force English or other colonial languages on Indigenous peoples. So I'm wondering if you can sort of keep what do I want to say, teasing that out a bit, right? So if sort of residential school in our past and the doctrine of discovery is based on this idea of superiority, how then does the UN Declaration get us towards reconciliation? And you use the word self-determination. And again, a big word, sometimes really loaded because people have different ideas of what it means. Where does the UN Declaration start taking us?
Yeah, okay. Yeah, great question. Thanks, Brenda. So, as I said, one of the very first things the Declaration does is it rejects the doctrine of discovery, and that's in the preamble, right? So it affirms that all doctrines based on the inferiority of peoples and advocating the superiority of other peoples are false and legally invalid, right? So it rejects that doctrine of discovery. Then, in one of the first articles, Article 3, it affirms the right of self-determination for Indigenous peoples. And then there are a whole bunch of other articles that basically go on to explain what that means. And to put it into a nutshell, what it means is that Indigenous peoples have the right to govern ourselves, to engage in self-government, and to do that in accordance with our own laws, our own political institutions, our own legal institutions, and our own normative principles, right? So we're entitled to govern ourselves not just as little mini versions of the Canadian state, but according to our own laws.
Excellent. And maybe that's the next place to start going, because I want to weave that into this as well. Is Indigenous people's own laws. Maybe we'll start at really foundational. There may not be a lot of people today who've thought about this, but when we talk about Indigenous law, what are we talking about?
Okay, that's a really great question as well.
Sorry, it's a hot seat. Did I tell you it's going to be a hot seat that you're sitting on today?
So I would say that there are probably different schools of thought on that. So some people would advocate that any law that an Indigenous people adopts for itself is thereby an Indigenous law, right? So the very fact that an Indigenous people has adopted it, has endorsed it through its own methods of governance, that in and of itself makes it an Indigenous law. There are others who argue for a more foundationalist view of Indigenous law, and who argue that those laws that Indigenous people adopt that are grounded in the constitutional norms of an Indigenous people, those are Indigenous laws. And what I mean by constitutional norms are essentially the customary laws of an Indigenous people that, at least from the Indigenous nations that I'm most familiar with, which is the Anishinaabe Nation, they're ultimately grounded in laws that come from the natural world and from the Creator. So those are sort of two viewpoints. And it's not for me to say, which is right, but those are the two viewpoints that are out there that I'm familiar with.
Yeah. And can you maybe provide a bit of an example from maybe both camps, actually, or both perspectives on what is an Indigenous law?
Okay, yeah. So the first one I talked about, the one that says, anything that an Indigenous people adopts through their governance system, thereby is an Indigenous law. My understanding is that John Burroughs, who is the leading scholar on Indigenous legal issues in Canada and perhaps the world, that he has articulated a kind of version of this. So he has a book called Canada's Indigenous Constitution, and he identifies 5 sources for Indigenous law in that book. And one of them is positivistic law, which basically says that if, for example, a First Nation passes a band council resolution or a band council bylaw, that thereby is an Indigenous law, right? Because they passed it through their system of governance that they are using, that they've endorsed. in contrast, the other view, which says that in order for an Indigenous law to be an Indigenous law, it must come from a more foundational source. So that view, and I'm going to speak now about Anishinaabe law specifically, so I avoid a pan-Indigenous approach. So the pan-Indigenous approach it happens when you fall into the sort of trap of talking about Indigenous law generally without being specific. And of course, sometimes it's legitimate to do that. But if you do that too often, you tend to engage in generalizations that aren't accurate, right? Because different Indigenous peoples have their own laws, and there are variations and differences. And so whenever possible, it's best to try to avoid that overgeneralization and to talk about specific Indigenous peoples' laws. So I'm going to switch now and just talk about Anishinaabe law specifically, so I don't do that kind of pan-Indigenous thing. So my understanding of Anishinaabe law, and I just want to sort of cite some sources here. So what I'm going to describe, I'm drawing primarily from the works of Aaron Mills, and Aaron Mills is a member of Couchiching First Nation, and he's currently a professor at McGill's Faculty of Law. So what he describes are the foundational norms that exist at the sort of most basic level, and then give rise to Indigenous laws. And the term that's often used for these more foundational norms within Anishinaabe law are the original instructions. And other words for this are creator's law or sacred law or the laws of nature. And if I were to put this into one sentence, I would describe it this way, and I want to premise this by saying that this is going to be really reductive, meaning that anytime you try to say something like this in one sentence, you're going to be missing so much of the important nuance and sophistication. But I'm going to do my best to say something that is accessible and can be said like in a sound bite. So what's at the heart of this is that the natural world, the earth, gives everything that we need to live a flourishing life to us as a gift. In other words, everything that humans need to be, to live in a good way, to live in accordance with Minno B'Madswin, to live the good life, to live a flourishing life, is given to us by the earth, by the natural world as a gift. All we need is what the earth has given us. And that principle, in turn, we can take guidance from it. And that guidance is that we, in turn, have a responsibility to give our gifts to all of those with whom we are in community. So all the different members of our community, we have a responsibility to support them, to learn what their needs are, and to develop our own gifts so that we can give those gifts to them. That's really the heart of Anishinaabe law as I understand it. And from that principle, we can then extract what our responsibilities are in any given situation, right? In any given situation we find ourselves, we should be asking ourselves, what are the gifts that we have that could help in this situation? And what are the needs of other people in this situation that we could meet with our gifts? And in order for a principle to be a law of a principle of Anishinaabe law, it should answer those questions, basically.
Amazing. Thank you. And I really loved that description, and I want to sort of chat about a couple of things. I have so many thoughts running through my head, and we've got to work through them slowly and sequentially while getting through them in time to take some of the audience questions too. But I think both ideas are not mutually exclusive, right? And part of what the first one you spoke about, John Burroughs, I want to highlight that aspect because I think they're both important, and recognizing both of them when we start thinking of reconciliation and a framework for reconciliation is the John Burroughs approach, I'm going to call them this way, and neither John nor Aaron are going to like that I'm naming their approaches by their names, but is a very forward-looking one. And I think it's important because it reminds us that Indigenous peoples, we are peoples today. We are current people. We are modern people. We exist today. And our legal systems are also forward moving and, continue to exist, right? And the Aaron Mills approach also reminds us that we are grounded people, right? That we have traditions that are very long standing, that are the basis for which we are passing modern laws, and not in the holding us back sense, right? But in that, we have ways we make these decisions. And so I really appreciate you bringing out both of those examples, because I think when we talk about the UN Declaration on the Rights of Indigenous Peoples as a framework for reconciliation, it's meant to be forward moving, right? How do we recognize our past? How do we acknowledge our current relationship, our present, and move us in the future, right? And so the ideas that you've been pulling out about self-determination and Indigenous law is about Indigenous peoples moving forward according to our own laws and making decisions for ourselves. And I tend to highlight in my work, right, that, let's recognize all the decisions governments have tried to make for Indigenous peoples based on racism of European ways being superior, paternalism of we know better than you, kind of connected to that racism and superiority. And so what we start to see, I think, in the UN Declaration is this idea of Indigenous peoples making decisions for themselves and recognizing the capacity to do so. And I'm going to change up where I was going to go, because I want you to pick up one other point here that you started talking about, which was the Anishinaabe constitutionalism and viewpoint of starting with what are the gifts that I have and what are the needs. Can you speak a little bit to Indigenous law and the UN Declaration and reconciliation as in actually bringing us together? Because I think for some people, these ideas that we're talking about are really scary and they sound like they're going to tear us apart and we're going to all be living separately. So how is this a framework for reconciliation, bringing us together if it's about Indigenous peoples doing their own thing under their own laws? How does that reconcile us? Just an easy question for you, Karen.
Yeah, okay. But I absolutely agree. My understanding is, and again, I'm very much influenced by what I've heard you talk about, but my understanding is that the UN Declaration is meant to be a bridge. And the way I see that working is I'm going to, before I get to that, I'm going to sort of talk about two trends that overlap a little bit with what I've talked about already. And the first trend is known as the reconciliation trend, and the other is known as resurgence, or the reconciliation approach and resurgence approach. And as I understand it, the reconciliation approach essentially is optimistic about the possibility of us achieving a way of living together, a way of the state and Indigenous peoples living together that makes use of the institutions of the state. So Canada's political system, Canada's legal system. In other words, that it's possible to achieve reconciliation by making room within Canadian laws for the operation of Indigenous law. That's the reconciliation approach. Now, in contrast, the resurgence approach says we cannot engage with the Canadian state, because if we do, that's a tacit admission of the legitimacy of the Canadian state. And so we need to simply operate on our own, right? We need to just focus on rebuilding our own Indigenous legal systems, our own Indigenous political systems, and we can't be contaminated by those institutions of the state. We need to focus on decolonizing ourselves and then the resurgence of our own systems of law and political systems. So as I see it, the UN Declaration seems to be an attempt to bridge those two approaches. And it does that by, on the one hand, still having a vision for the interaction between the state and Indigenous peoples, right? So it's not talking about Indigenous peoples being completely isolated or separating off from the states in which they exist. It has a vision of there being some interaction between the state and Indigenous peoples. But at the same time, it's affirming the operation of Indigenous laws in a number of ways. So it allows for the free, prior, and informed consent of Indigenous peoples before the state engages in a number of different kinds of actions that affect Indigenous peoples and our territory. It also provides for the operation of Indigenous law with respect to Indigenous self-determination and self-government. And so that's why I see it trying to be a middle ground or bringing together those two different approaches.
Amazing. And I think that's just it. They don't have to be dichotomous or like, mutually exclusive. It doesn't have to be one or the other, right? I wanted to, I remember where my brain was going. Going into law professory kind of mode, I still think that there's going to be people in Canada who have difficulty wrapping their head around the idea that part of reconciliation is that some people in Canada might live under and follow different laws than other people. And, because we've known each other a while, I know that you've taught some of this in Canadian law schools, right? So in schools where people are going to learn how to be a Canadian lawyer, Indigenous laws are now being included in various ways. Can you maybe talk about or address some of that fear? And I'm just thinking you might have some interesting experiences having taught some of this in Canadian law schools for a few years. We'll just say a few, Karen.
Okay. Yeah. I mean, I'll jump in here, but then I also, love to hear your perspective on it. So like what you're talking about is an extremely important question. And I want to, just acknowledge how valuable of a question that is by stating it at its highest. So when people talk about, how could there be two different sets of laws operating in Canada? What they're appealing to is liberalism, right? They're appealing, and liberalism is built on the twin pillars of individual equality and individual freedom or autonomy. And when we talk about how could there be two separate laws, what we're really getting at is this notion of equality, of individual equality, right? That the notion that there can be certain rights or certain laws that only apply for a subset of the Canadian population, that seems to violate the principle of equality, right? Because not all Canadians get to have Indigenous rights. And if there's separate laws for one group, it doesn't seem to be applying equally to everyone. So then we have to ask ourselves, is this really the case that what we're talking about, the operation of Indigenous laws, does that violate liberalism? Because liberalism is or liberal democracy is sort of the governing principle of Canada, right? So our Canadian Charter of Rights and Freedoms is the practical instantiation of liberal democracy. So in order to answer this question, does the operation of Indigenous law, does that violate liberal principles? Does that violate the principle of equality? We need to go back to the Doctrine of Discovery that we talked about. And the short answer is that actually it's the Doctrine of Discovery that violates the principle of equality. It's the Doctrine of Discovery that is counter to liberalism, because it's the Doctrine of Discovery that says that one people is superior to another people, right? It's the Doctrine of Discovery that doesn't support equality of peoples. And I said earlier that the Doctrine of Discovery is still operating in our legal system. It's operating in our legal system insofar as Canada asserts unilateral and complete sovereignty over this territory and only acknowledges Indigenous peoples' ability to govern ourselves to the extent that that is downloaded from Canada's sovereignty, right? It doesn't truly recognize, or I should say, simply allow for the operation of our, as Indigenous peoples, own inherent right of sovereignty, right? Our own inherent exercise of jurisdiction, our own inherent governance over ourselves using our own laws. So if we're concerned about equality and liberalism, what we really need to be concerned about is rejecting the Doctrine of Discovery and ensuring that Indigenous peoples can govern ourselves according to our own laws on an equal footing with non-Indigenous people.
I love that answer. I don't know if I've ever thought through it in that way. And it reminds me of a story or a learning that I had. So as you mentioned, I've been doing some work around the UN Declaration for a while now. And I remember years ago giving a presentation at the Treaty Relations Commission Manitoba, where I also have the privilege of doing some work. And I can't remember I think it was during the question period. One of the elders, and he's actually mentioned in the chat, Elder Bones, someone I've worked with for a while, was like, you start with like the impacts, the injustices of colonialism, but we need to start with our strength. We need to start with who we are as Indigenous peoples. And so he encouraged me when I was doing my work of educating people around the UN Declaration to make sure I was starting the story with Indigenous people's strengths and not the negative impacts of colonialism on Indigenous peoples. And so I was like, that's really important. Thank you, Elder. And I went back and I reread the UN Declaration again. And lo and behold, the very first preambular paragraph, the very first articles are about equality and non-discrimination. And so really what we're trying to do is ensure that Indigenous peoples are treated as peoples, right? And to be really blunt, I mean, you were amazing in your description of the Doctrine of Discovery, but you avoided the really horrible words that are used in the cases. How did Europeans justify this? Because Indigenous peoples were fierce savages whose occupation was war. Right? So that very blatant racism as the foundation. So what we're trying to do is through the UN Declaration is, Sagat Henderson taught me this, is it's about humanity, right? That Indigenous peoples are peoples, that we're people, right? And so I really appreciated that explanation of tying that together. And bringing it back, and you also answered one of the questions that our audience had posed. The other point that I want to highlight, and I think I've heard Jean Taillé say this, who's a Métis lawyer. Canada is a very interesting place to study and think about law, because I think we're probably one of the only countries in the world where there's a province that already is recognized as operating under a completely different legal system. So both you and I went to law school, and we went to a school where we learned the common law, the sort of British common law, the English law. But in Quebec, they use the civil law and the civil code. And it's such a different type of law and way of learning the law that you and I can't practice there. We can't just pick up and go start working, where we can go practice in every other province and territory. But it's so different, actually, that they don't just let, a common law lawyer show up, right? And then the other point that I don't know if you want to sort of circle back, but I thought maybe we could weave in here, was part of the concern also about, oh my God, what do you mean Indigenous law could be operate? You use the word recognize, right? We also need to realize that Indigenous peoples have been living by this law. It already exists, right? So you were talking recognition. I don't know if you want to sort of say a little bit more to that idea, because you use the word inherent and you talked a bit about this, but I think part of this, you know, on the Stereotypes Day, we were talking about the matrix, right? And sort of part of what we're doing is like seeing behind the matrix. And do you want to sort of shed or talk at all about that idea that Indigenous law does exist and already operates regardless of if we recognize it?
Yeah, absolutely. And I want to pick up on the point that you made as well, Brenda, because I couldn't agree more. And I just want to acknowledge, I think I've heard Eric Adams, who's a faculty member at the University of Alberta's Faculty of Law. I think I've heard him make this point. So I just want to give that shout out. And it's that, you know, when we're talking about this question of how could there possibly be two different systems of law operating in one country, you know, if there's any country in the world who is well positioned to do this, it's us in Canada, because as you said, we already have a federal system. We already have Quebec operating with a different system of law. So, you know, it's not only is it not difficult, but it's already happening. It's, you know, it's literally happening and has been for, you know, more than a century. But so you asked me to talk about recognition versus inherent rights. So yeah, this is also an important point within Indigenous scholarship and Indigenous peoples advocacy. So what we as Indigenous people are advocating for is the operation of our laws in accordance with our own inherent jurisdiction, meaning that our laws have already operated, as Brenda said, since time immemorial. And I was reminded of that at a talk that I was sitting in on yesterday by Elder Fred Kelly from Treaty 3 territory. And so I just want to mention that since it's top of mind, since I just heard him speak yesterday. And he made the point that, you know, as Indigenous people, we have been here, we have been existing and governing ourselves in, you know, in a healthy way since time immemorial. So how did we do that? Well, we did that with our own laws, right? With our own system of law. And so what we're not asking for is a stamp of approval from the Canadian government. What we're saying is that we want our laws to be effective and operative, not because Canada says it's okay, right? Not because Canada says, okay, this law of yours is okay, but this one's not. Oh, and this one will be okay, but then this one not, right? We already have a system of law and the ability to operationalize those laws on our own without Canada being the one who oversees it or gives us recognition.
Excellent. Yeah. And, you know, I often think about this sometimes when we start talking about reconciliation and, you know, where do we go? And that a lot of what I see the work ahead is that stepping back. And I think you use the word making space, right? So it's not that we need Canada to do more for us, but we actually just need to like peel back a little bit, right? Create some of that space in the landscape for these things to, for Indigenous laws to continue to exist. And I want to come back to something that's sort of coming out in the questions, and we've gotten lots around the doctrine of discovery. I didn't sort of anticipate this being a doctrine of discovery conversation, but I kind of like it. So again, I think from my experience, the current reality in Canada is what everyone knows. And so there's a comfort in what we know, even when it's not perfect, right? And so what is that saying? The devil you know is the devil. Anyways, that someone could help me on that one. But if we don't base Canada on the doctrine of discovery, then what? Like, what do we have a hole in Canada? Does Canada cease to exist? Do we crumble? Like, I think there's an unknownness and a fear that exists amongst many Canadians that holds them back from supporting change because they don't necessarily know or see the future. And maybe just a little bit from your perspective, like if it's not the doctrine of discovery, what do we do? What exists? What's behind the matrix?
Yeah, okay. That's a really great question. And when you say, if the foundation of our country isn't the doctrine of discovery, does that mean there's a hole? Yeah, there is. There is a gap right now. It's a gap in legitimacy. There are, and when I say this, I'm not being original. I didn't come up with this. There are many, many Indigenous advocates, Indigenous nations, peoples, and non-Indigenous people as well, and scholars who have made this point before me, which is that Canada's assertion of sovereignty over Indigenous people and over Indigenous territory is illegitimate. So de facto, it exists. We can look around and see there's streets, there's infrastructure. On the ground, it looks pretty permanent, but ethically speaking, morally speaking, it's illegitimate because it's grounded in the doctrine of discovery. So how do we fix that? What can be done? So I don't think that there is one single answer because, again, it's important to avoid a pan-Indigenous approach. I think that every Indigenous nation is entitled to say for themselves what is going to be the answer for them to fix that lack of legitimacy on Canada's part. Each Indigenous people can decide for themselves what is going to be a good relationship. My understanding is that for treaty peoples, the answer is to comply with the treaty responsibilities as they actually exist, not merely based on what's written in the English version of the treaty. Now, and I don't want to speak for all treaty peoples either, because again, there can be differences. And for those who don't have a treaty, then Canada has work to do to either enter into a modern treaty or to otherwise enter into a good relationship for those Indigenous peoples. Now, when I say the treaty as it actually exists, again, I don't want to speak for all treaty people, but my understanding is that for many of us, what that means is the treaty as understood through, and perhaps I'll just talk about Anishinaabe treaties, as understood through Anishinaabe law. So in other words, what I understand is that in order for Canada to be in a good relationship with us and to fill that gap of legitimacy, Canada should be acting in accordance with Anishinaabe law when it engages with us. So Canada should sit down and ask itself, what are the gifts that we have as the Canadian state? What are the needs of these Anishinaabe treaty people? How can we as the Canadian state develop our gifts in a way that meets those needs? Because we as Anishinaabe treaty people have already given a huge amount of gifts in terms of Canadians being here on our territory and using this territory, right? That's an incredibly extensive gift, the ability to be on this territory. We didn't give over sovereignty, but Canadians are here on this territory and using it. And so what are the gifts that the Canadian state can give to Anishinaabe treaty people to ensure that we are living in a flourishing way? And one of those gifts is to allow us to govern ourselves in accordance with our own laws.
Yeah, and I think that's such an important point also. Because one of the things that I often think about is being honest with ourselves of the state of Canada, right? So sometimes I think, because a lot of people in Canada are okay, right? That, sometimes we say people benefit from this system, but, for most people in Canada, maybe it's okay, right? And so I think they just want to say, well, we just have to tinker a little bit. They don't want radical reforms because they only see the problem from their perspective and see a little problem, right? That most people are okay, some are not. So we just need to tinker a little bit to make it okay for everyone. But I think part of what you're getting to, and a part of what I see, is that we need to start being honest with ourselves about where we're at, right? That the problem may not be a little tinkering, it might be foundational. And sometimes I even use the analogy of my basement, and maybe you can relate because we've also talked about renovations, but like sometimes there's some water in my basement. I don't really know where it's coming from. It's never been a huge problem, but I know after a lot of rain, if I go into like the storage room of my house, there'll be a little pool. And so like most of the time I just close the door and I don't go in there when it's raining. So in my head, most of the time, most of the days, I can say my house is fine, right? But that doesn't actually mean there isn't a problem. And at some point, right? And so I think part of what I hear survivors speaking to about really learning the truth and this journey is really recognizing how broken we are, and that if we want to be a Canada that lives up to the values that we espouse, we fix those, and that dealing with the real foundation of the problems of the broken relationship is actually going to move everyone forward, right? It's not that, it's not a scale. So it's not like to help Indigenous peoples have the same economic, you got to bring everyone down, right? Like it actually, I see human rights as about lifting everyone up. It's about bringing people up. We talk about it being the floor, right? So it's not like we're going to put other people in the basement. And so, I just looked at the time, and lo and behold, I think we're down to just like 2 minutes. So I've tried to get us to talk through some of the questions, but I would love you to give some closing thoughts. And just as out there, one of the questions are, could you share some of the differences between, Indigenous law and Canadian law? And I don't know if you happen to have an example of the differences, and one that maybe it serves us all. I don't know. This isn't a pre-planned question, but yeah, any closing thoughts, remarks, or anything on that question?
I can certainly try to give a soundbite about the core difference between Anishinaabe law and Canadian law, which is grounded in a liberal approach or liberalism. So I mentioned that within Anishinaabe law, the starting point, the most foundational point, are the original instructions given to us by Creator of the natural world, also known as sacred law, Creator's law, or the natural laws. The starting point for liberalism is not that. It's the autonomy of the individual, right? So the individual is the rights bearer. And an individual's freedom or autonomy is protected by, as I said, these twin pillars of individual freedom and individual equality. And the way that those are protected within liberalism is through the principle that each one of us is entitled to decide for ourselves our own conception of the good life. No one can dictate to us what that is, not the state, not anyone else. We get to decide. In other words, what our values are, how we're going to live, as long as we don't cause harm to others, right? That's the caveat that liberalism gives. But as long as we're not causing harm to others, we decide how we're going to live and what the good life is. In other words, we get to make up our own original instructions. And each one of us can have different original instructions that we made up ourselves. Within Anishinaabe law, that's not the case. The original instructions are given to us. Now, those two foundational differences then inform the laws of each of those societies and result in other differences between them. But that's what's at the heart of the difference, as I understand it.
Mm-hmm. And I think, from my perspective, I'm just going to respond and then we'll wrap up here. But that sort of fear of having some sort of infringement on your individual thing is just because what I get is immense support from my community, right? Like there's a give and take, and my community gives and supports, right? So, and I don't even feel limited by this sort of communal aspect because I'm happy to give of myself to support my community, and my community and my world supports me, right? And I don't want to go it alone. So I really thank you so much for joining us. I thank you for sharing your amazing thoughts and perspectives on this topic, walking us through the doctrine of discovery in a way that I think is accessible, where people can start to see a new Canada. Not built on falsehoods, but based on real notions of equality. And so just thank you so much, Karen, for joining us. I'm going to share my screen really quick because I just want to let people know I will be putting up some information about some additional resources that we have. I quickly added in John Burroughs' Canadian Indigenous Constitution. You made some references to his work, and that's one of the ones that I really enjoy. Of course, there's many more. I also wanted to let people know that we have been partnering with Meta to share some information about the history and legacy of residential schools through Messenger. So there's a QR code on the screen that you can go through to learn a bit more about the history. And just a thank you to everyone who joined us, the over 2,000 participants we had today. Thank you for continuing to sit with us on this journey and learning about the UN Declaration as a framework for reconciliation and how Indigenous laws plays a role. A reminder that we have a session again tomorrow where we're going to talk about taking action towards reconciliation with residential school survivor Jimmy DeRocher and Dale Clare from Canada Post, and they'll talk about their experiences of working together on a project. And if you want more information about our work, please go to our website. So thank you so much, everyone, for joining us. And thank you, Karen, for joining us today.
My pleasure. Thank you, Brenda.